Some of you may be curious to know as to why there's a talk included about relief from sanctions, given that in reality, since the 8 years the famous case of Denton was handed down, nothing has really changed in terms of the guidance or the CPR. But in saying that, in reality, despite the optimism of the judges in Denton, these cases are 10 a penny, and I suspect there's probably no one in this room that hasn't at some point or another made a mistake in the conduct of litigation and felt the need of some advice as to how to deal with it. Also, as I've highlighted in the handout, it is now coming up to the 10-year anniversary of Plebgate, and what an appropriate way to celebrate that. And to put this into context, this is how it started. In reality, it started with the CPR and the imposition of C 3.9, but this is to be a short talk, and if we were to start there, that would be immensely dull. So I thought I would remind everyone of what happened when Andrew Mitchell, who was then the Chief Whip, had the temerity to try and cycle out the main gate of Downing Street as opposed to the pedestrian one. A little bit of an argument with the police officer, and it was reported by The Sun that he called the officer a pleb, amongst other choice words. He then made the rather drastic decision to sue The Sun for libel, accused the officer of lying. The police officer then sued Mr. Mitchell for defamation, and that led to very expensive litigation. And if you thought Wagatha Christie was interesting, well, you should read Plebgate again. But the point that arose from this litigation is, you may recall, some of you who were practicing at the time, this was in the early days of cost budgeting, and Andrew Mitchell's solicitors who were representing him were a very important and expensive firm in London. They had many other important and expensive cases to run. They were very busy. They missed the deadline for filing their cost budget, and when they went to explain why, that was more or less loosely the explanation they give. And at the time, they were expecting that the normal course of action and convention in these matters would have just been nodded through. The court, at first instance, dismissed that, and they were reduced to their court fees only. They appealed, and this is where a fairly significant change was put in place. The Court of Appeal dismissed their appeal and said that a more robust approach needs to be taken in terms of the enforcement of rules and compliance with the CPR. My one anecdote for today is that the robust approach that was taken to one of my cases was weeks or so after Mitchell was handed down. I had the joy of travelling to Kendal County Court on a Friday afternoon for a road traffic accident case. My side statement was filed and served 2 days late. It affected absolutely no one, had no prejudice on anyone, and we all expected to crack on and argue who crashed into the bus. 5 minutes after walking into court, I walked out, having been struck out on the basis of Mitchell, and somewhat unusually, that experience seemed to be more or less reflected up and down the country. The Court of Appeal saw a bit of sense in Denton and rode back a little bit and set out their more pragmatic approach, which I'll go on to address. But the purpose of today and the time available is really to see what's happened since Denton, assess the lay of the land there, and highlight one or two important cases that have provided guidance. I noted Vilma talked about 3 cases, so did Seth. I was counting, I think I'd mentioned 22 or 23, which was wholly optimistic for a 20-minute talk. But I'll rattle through what I consider the most important ones in terms of, importantly, as a solicitor, how to advise your client on how to deal with these applications when making them, when you or the client has led to the error that requires the application, or what I would argue is probably the more difficult, well, certainly requires a little bit more judgment, is how to respond to them, when to oppose them, and when to consent, and when to adopt the Swiss approach of remaining neutral. Those are the subjects I was hoping to cover. I'm conscious we may not get through all of them. I don't have to deal with the Denton Test very long, because everyone in this room will be familiar with it. I have included the rules in the handout, simply to say, to make the point, well, 2 points with 3.8. That is the power of the court to grant relief, and and it states that the other side, the innocent party, doesn't actually need to apply for the sanction to have effect. It's incurred automatically. They may need to draw it to the court's attention. The second aspect of Rule 3.8, which you're no doubt familiar with, is you do need the court's order to grant relief. Now, that can, of course, be obtained by consent, can be dealt with on paper, but it's not enough to agree with the other side for relief. The court actually has to approve it. And noteworthy in Rule 3.8, it states that in order to actually obtain relief, party needs to apply. As we will go on to see, that's not strictly speaking true, and we'll examine how to actually apply and what, if anything, a party seeking court's indulgence is required to do. 3.9 is the one that everyone's familiar with, which simply sets out the guidance, and it's 3.9 and the Denton Test that are to be read in conjunction with each other. Essentially, 3.9 was provision that told the courts what they were required to consider. Denton then said effectively how they were required to consider that test, and in particular stage 3, which is the key point in every single application. In terms of sanctions, I've mentioned the Wolf Rock case simply to highlight the point that not every sanction needs to be expressed on an order. The usual example is if a party fails to file witness statements in time, and they will not be entitled to rely on one. Often we see orders that simply say that the time for filing statements is day X. Clearly a sanction not being able to rely on that in that occasion is implied. And there's other cases where the court has a little bit of discretion to decide or determine the sanction when one isn't expressed or implied in the order. But the more important subject for today is how do the court really enforce that guidance, and what do they do when a party makes an application. As I said, the reality is that in court, when we get to this stage, judges tend to not quite skip through stage 1 and 2, but their focus is on stage 3 and dealing with the case justly. 1 and 2 are relevant, as we'll see, in terms of how that's to be applied, but it's rare, particularly in a case where an application is opposed, for it to be granted on stage 1 on the basis of a lack of seriousness, or on stage 2 on a lack of good reason. I've included the quote that was taken from Denton, the optimistic quote where the Court of Appeal stated it should very much be the exceptional case where contested application for relief from sanctions is necessary. Researching this talk, there was literally hundreds of High Court and above authority that have included. And credit to a barrister in Bristol, Rachel Siegel, who's produced a helpful table of, I think, over 300 cases since Denton. Those are just the authorities that are reported. In my experience, I'm doing at least one of these applications a month, probably more, and those are the ones that are actually contested with statements. It's all, not quite every time, but often case management hearings at morning of trial, one party or the other discovers that they've missed something, and you have to make an informal application. The question is, despite what 3.8 says, that the parties need to make an application to obtain relief, do they? Unsurprisingly, the Court of Appeal have given a very generous interpretation to that rule, and as the 3 authorities I've included make clear, that is not, strictly speaking, required if you're in default, although the rule stated you do not, strictly speaking, need to make an application supported by evidence. However, doing so, particularly in circumstances when you're aware that you're in default, and electing not to file a formal application or not to file evidence, is a fairly risky strategy, and not least because, as the Court of Appeal in Park confirmed, there's an additional hurdle for the parties who don't file a formal application to get over before the actual substantive test is applied. And the 3 points that are to be considered is firstly asking why there hasn't been an application, what is the impact on the other side, not being a formal application, and whether the court has sufficient evidence to justify the granting of relief. Prejudice and evidence also come into the actual substantive test. The reality, in my experience, is this was often raised, certainly before Park came out, when at a case management hearing, a party may not have actually realised, due to an erroneous calculation of the dates, that they were in default. The other side would sometimes pop up and say, well, you can't actually grant relief today, Judge, because there's not been an application. This avoids, or those authorities avoid that, what I consider to be unnecessary argument about whether a formal application is required. But as Park says, if you elect not to file a formal application, the time for granting relief will be exercised sparingly. Back to Denton and the guidance, just addressing very quickly stage 1 and stage 2. It used to be the case, particularly shortly after Mitchell and Denton came out, that all judges took the view that if you're in breach of an order, that was a serious and significant breach, and it was quickly move on to stage 2. Why that occurred? Johnny Depp, who most of you will have seen was recently in the pub next door, was kind enough to deal with some of that confusion in his English case on defamation, was confirmed in that case that filing statement 1 day late, which still left 8 weeks until the trial, was not actually a significant or a serious breach. I know some local judges may take a slightly stricter view, but there is authority to that effect, and there's another case, Diamonds, where not filing an acknowledgement of service on time when a party was unaware of the dates is neither serious nor significant. Most cases, though, if you're in court and if it's being contested, it's going to be a serious breach. Stage 2, good reason. Again, there are very few cases, very few reported cases where relief has been granted on the basis, or certainly on the sole basis, that there was a good reason for the breach. Some examples were given in Mitchell. There was only 2, where a solicitor suffering from a severe illness or being involved in an accident, or due to the time for compliance being unreasonably close after the order was made. But it was also the court in Mitchell who denounced any idea that simply being busy or overworked as a solicitor amounted to a good reason. I've included the quote there from Exotech, where it states, well-intentioned incompetence is not a good reason. It's helpful to know, but examples of good reason, another case is Patterson and Spencer. And that's probably the most common one, where a party in default is simply unaware that the order has been made, or unaware, particularly for litigants in person, as to the effect or the requirements of that order. Oversight by a solicitor or by a party, by a litigant in person, is not a good reason. The important point and the main issue that arises in stage 2 with this aspect of the guidance is the mistaken assumption made by parties that they will have to either show a good reason, or if they don't consider that there is a good reason, there's no need to explain what happened in the application. Reason is not to be confused with mitigation. Reason is why the breach happened and what led to it. Mitigation is what happened after it and what steps were taken to remedy it and to ensure that the litigation continues on a smooth path. The fact that you, as the instructing solicitor, may feel that your client who's caused the breach has not given you a good reason for that breach occurring does not deflect from the requirement to explain in a statement why that default came about. And I've included the case of Rapid Displays, where His Honour Judge Pearce emphasised the need in any application for relief from sanctions that a party can be expected to come before the court with a full explanation of how the need for the application came about. Essentially, whether you're contending for a good reason or not, it is always advisable to include in the application and include in the statement why the default occurred. And in that case, amongst other reasons, but the lack of an adequate explanation was one of the key reasons why relief was refused. Finally, as to the guidance, the third and key test, all the circumstances so as to enable the court to deal justly with the application. And this really was the real key departure from Mitchell. One of the most helpful examples in this regard as to how that, or what factors are to be considered, is the case of Razak, which I've included. This was not an uncommon case where a party failed to file and serve a witness statement on time, but it's one of those cases where it's a High Court authority and provides a fairly short and helpful summary of what factors are to be considered and effectively a checklist on what you as a solicitor should seek to address and include in any application. And those 7 factors or so, you will note that they broadly reflect the factors set out in the overriding objective. There's nothing surprising there, but those of you who have appeared in court dealing with these applications will no doubt recall those are the factors that more often than not are addressed in every single one. As to those factors, the ones that I consider to be the most important and have the greatest weight are delay, prejudice, and arguably the most important of all is the effect of the court timetable. So I skipped a slide. I'm conscious of the time, but dealing with delay briefly, it is very difficult for me to overstate and overemphasize the importance of making an application promptly when seeking relief. There are any number of authorities on this point. I've included 2. One recent one to show or reflect the Court of Appeal's view in this, when they stated it's axiomatic to act promptly. And another is the Kamathi case, which was the Mau Mau case, group litigation. I highlighted that simply to reflect the fact that the only reason that the application was refused in that case was because of the delay in making it. There are plenty of cases like that. There's plenty of authorities like that. If you're going to do anything when advising a client or when clearing up your own mistake, the most important thing to start is make the application promptly. Evidence can be submitted at a later date, but promptness is key. Prejudice was the second reason I considered to be given the greatest weight. It's almost inevitable in these applications that the other side, if they're going to oppose it, are going to complain of some form of prejudice or another. It is, however, and this is something to consider when you're determining whether to oppose an application, it is not a requirement for your client, your side, to suffer prejudice for that application to be refused and dismissed. It is, however, a requirement that if you're going to rely on prejudice and if you're going to argue about a particular form of prejudice that may not be obvious, to include a statement to that effect, setting out what prejudice is and how it's caused. It almost goes without saying, but if this is the key component of your response, stick it in the statement. Losing the trial date, are you doomed if your breach or your client's breach has caused the trial to be derailed? Not quite, but you're going to face an uphill battle to persuade the court otherwise. It is probably the factor that's given the greatest consideration to by the courts, particularly for trials, in particular for trials that last longer than a day, not least because it's almost inevitable as to the consequences that flow from the loss of a trial date, such as costs, delay, and further prejudice to the other side. I've included British Gas, as that was one example. And again, there are many when the fact trial date was lost was grave concern, was the primary reason why relief was refused. As I say, I was optimistic to try and get through all of this in the circumstances. Merits of the case, quickly, they can be considered. If you think you've got a strong case, the authorities say limited circumstances. In reality, the County Court and the High Court will consider them, include it in the statement, particularly if it's obvious. Opportunism. I'll finish on this because, as I said at the start, this is arguably the factor that requires the greatest judgment, particularly in circumstances where, through no fault of your own or your clients, you're potentially receiving a windfall merely due to the other side's mistake or negligence. Why shouldn't you take advantage of that? Well, not according to Denton. The court stated it would be inappropriate for lawyers to take advantage of mistakes made in the hope that relief will be denied and they will obtain a windfall strike. What to do, because the consequences of opportunism will almost inevitably result in a cost order, and one authority can even lead to indemnity costs. Effectively, you need to consider those factors that we've touched on. What is the impact of the relief? Is it a serious breach? Was there any good reason for it? What impact is it going to have on your client and on the trial timetable? If there's no impact on your client, there's no impact on the court, you can get on with it. More often than not, you should really be considering whether simply to just nod the application through. The difficulty, as with any area of law, is this is not black and white. It requires a degree of judgment. It requires a bit of thought. There's no short answer and there's no strict guidance to be given. One day may be serious in some cases, it may not in others. But those factors that we've addressed, and in particular going back to the Raza case of that checklist, look at that and really decide whether it's going to be in your client's advantage to oppose this or not. There's two authorities on whether it should be included in set-aside judgments. One says no, one says yes. And your guess is as good as mine as to what the Court of Appeal is going to decide. The advice is work on the basis that it's going to be included, although most cases it's not going to have any difference on the outcome. Those are the gates of Downing Street closed. Thank you for listening. I'm sorry I've rattled through this. The main cases since Denton are included in the handout. The summary of today and what you need to take away is speed and transparency are key in dealing with any application, whether making it or opposing it. We are all human. Despite what the Court of Appeal thinks, as litigators, we are not infallible. The mistakes are made. They're made in every single case. They cannot be eradicated. The issue is more often than not the mistake in the first place. It's how a party and both parties respond to it. The reality is that any mistake or breach which causes a loss of a trial date, those are the cases where you're going to struggle. On the other side of the spectrum, any ones that don't cause the trial date to be lost or don't affect the other side will more often not be granted relief. That is the advice that I consider to be given to your client. And despite what the court said in Denton, these applications are not going away. So I hope the advice in that regard has been useful. And as I say, it's often said in other fields of business, it's easier to ask for forgiveness and permission. That does not apply in civil litigation. If you have the opportunity, ask for permission. You're going to be late or you're going to be in default, make the other side and make the court aware first and ask for permission to extend time. Don't think it's going to make any difference if you ask for forgiveness after, because it's going to make quite a critical difference. Thank you for listening.